Cyfraith Hywel, also known as Welsh law, was the system of law practised in medieval Wales before its final conquest by England. Subsequently, the Welsh law's criminal codes were superseded by the Statute of Rhuddlan in AD 1284 and its civil codes by Henry VIII. Series of laws in Wales, Acts between 1535 and 1542. Welsh law was a form of Celtic law with many similarities to the Brehon law of Ireland and particularly the customs and terminology of the Britons of Strathclyde. It was passed down orally by jurists and bards and, according to tradition, only first codified during the reign of Hywel the Good in the mid-10th century. The earliest surviving manuscripts, however, are in Latin, date from the early 13th century, and show marked regional differences. The law is only known to have been revised by a few rulers but was obviously updated by jurists in response to changing jurisdictions and circumstances, so that the surviving manuscripts cannot be considered an accurate portrayal of Hywel's first code. Notable features of Welsh law include the collective responsibility of kindreds for the members, the gavelkind inheritance of land among all and only male descendants, a status-based system of blood money, slavery and serfdom, the inability of foreigners to naturalize earlier than the fourth generation, and very lax treatment of divorce and legitimacy that scandalized the non-native clergy. Overview. The laws include the laws of the court, the laws laying down the obligations and entitlements of the king and the officers of his court, and the laws of the country, dealing with every other topic. In some versions of the laws, some of the material in the laws of the country are split off into the Justice's Test Book, dealing with homicide, theft and the values of wild and tame animals and other items. Within each of these sections there are tracts of varying length dealing with different subjects. For example, the law of women and the law of contracts. Civil law differed from most other codes of law in the rule that on a landowner's death his land was to be shared equally between his sons, legitimate and illegitimate. This caused conflict with the Church, as under canon law illegitimate children could not inherit. Once a case came to court, the method used to come to a decision was usually by compurgation. Under this system, the person accused of the parties to a dispute would give the version under oath, following which they had to find a number of others who would take an oath that the principal's oath could be trusted. The number of compurgators required depended on the nature of the case. The judges would then come to a decision. Capital punishment was only prescribed for a small number of crimes. Homicide was usually dealt with by the payment of compensation to the victim's family, while theft could be punished by death only if it was theft by stealth and the thief was caught with the goods in hand. The value of the goods stolen also had to exceed 4 pence. Most other offences were punished by a fine. Origins. Most of the surviving manuscripts of Welsh law start with a preamble explaining how the laws were codified by Hywel. The introduction to the Book of Blewyrod is a typical example. Hywel the Good, son of Cadel, by the grace of God, King of all Wales, summoned to him from every comote of his kingdom 6 men who were practised in authority and jurisprudence, to the place called the White House on the Turf in Dyfed. And at the end of Lent the king selected from that assembly the 12 most skilled laymen of his men and the 1 most skilled scholar who was called Master Blewyrod, to form and interpret for him and for his kingdom laws and usages. As each of the manuscripts dates from centuries later than Hywel's time, this statement cannot be used to date the event described above. Professor Hugh Price has demonstrated that some of the prologues were developed in response to attacks on Welsh law by churchmen and nobles who wished to gain rights more akin to those enjoyed by ecclesiastics and the aristocracy in England. In discussing Hywel's association with the law, K. L. Morn suggests, it is not impossible that the association of Hywel with the law reflects more on 12th and 13th century South Welsh attempts to re-establish the importance and influence of the line in an age dominated by the princes of Gwynedd. On the other hand, the Iorwerth versions, produced in Gwynedd, have exactly the same attribution of the law to Hywel and the council at Whitland as to the southern versions. It is more likely that Hywel's name was used to lend some form of ancestral authority to the laws. The best that may be said of Hywel's association with the law is that a folk memory recalled a revision and rejuvenation of the law during his reign. Other kings are said to have introduced later modifications to the laws. For example, Blethan ap Cynfyn, king of Gwynedd and Powys in the mid-11th century. Some of the legal material, such as the tract on the 7 bishop houses of Dyfed, may be dated to a very early period of law. Other material bears comparison with early Irish law manuscripts. Although there are a substantial number of manuscripts containing the law texts, there are no existing manuscripts of law texts dating back to the time of Hywel, and Welsh law was continually being revised and updated. There has been some debate among scholars as to whether the laws were originally written in Welsh or Latin. The Surrexit Memorandum in the Lichfield Gospels is a record of the outcome of legal proceedings dating from the 9th century and written in Welsh, and though it is not a law manual, it does indicate the use of Welsh legal terms at the time. The earliest manuscripts known are Peniarth 28, written in Latin but now generally thought to be a translation of a Welsh original, and Peniarth 29, known as the Black Book of Chirk, written in Welsh. These are thought to date from the earlier mid-13th century. There are a large number of law manuscripts written mainly in Welsh but some in Latin, written between this period and the 16th century. Later manuscripts have been shown to reflect legal developments, particularly in the southern Welsh lordships. Apart from the full compilations, there are shorter versions thought to have been working copies used by judges. However, they are all usually considered to fall into 3 redactions, known as the Cyfraith redaction, the Blegeirad redaction and the Iorwerth redaction. The Cyfraith redaction, thought to be linked to the area between the River Wye and the River Severn, possibly Melienid, includes some of the least developed law. It is thought to have been compiled in the late 12th century when this area came under the rule of the Lord Rhys of Deheubarth. The Blegeirad redaction is associated with Deheubarth and shows signs of the influence of the Church. The Iorwerth redaction is thought to represent the law as modified in Gwynedd during the reign of Llywelyn the Great in the first part of the 13th century by the jurist Iorwerth ap Madog. This is considered to be the most developed version of the law, though it does contain some archaic passages. The version in LLYFR: is thought to be a revision of Iorwerth, though also from the 13th century, and there is also the LLYFRY Damwain, a collection of case law linked to colon. No manuscript has survived from Powys, though the Iorwerth redaction does indicate where usage in Powys differs from usage in Gwynedd. Laws of the Court. The first part of the laws deal with the rights and duties of the king and the officers of the king's court. The order of precedence is set down: first the king, then the queen, then the etafed or edling, the heir. Next come the officers of the court. The Iorwerth redaction identifies 24, of whom 16 of the king's officers and 8 the queen's officers. First in rank was the captain of the household troops, then the priest of the household, then the steward, followed by the chief falconer, the court justice, the chief groom and the chamberlain. A list of additional officers follows, including such officers as the groom of the rein, the porter, the bakeress and the laundress. Each officer's entitlements and obligations are listed. It introduces a number of legal terms. Sarhad could mean an insult or injury of the payment that was due to a person in the event of an insult or injury, and this varied according to the status of the person concerned. For example, the Queen of the Edlings Sarhad was 1/3 that of the king. Galanas was a form of wergild and represented the value of a person's life in the event of a homicide and was set at 3 times the Sarhad, though the Sarhad was also payable by the killer. Durway was a fine payable for crimes and camlwrw a smaller fine for less serious offences, while ebidif was a death duty payable to the deceased lord. Sarhad and Durway are still Welsh words meaning insult and fine respectively. The origins of the various redactions are reflected in the relative position of the rulers of the Welsh kingdoms. The Iorwerth redaction manuscripts proclaimed the superiority of the King of Aberfraw, chief seat of the Kingdom of Gwynedd, over the others, while the manuscripts from Deheubarth claim at least equality for the King of Dynefwr, chief seat of the Southern Kingdom, while Welsh law lays more emphasis on the powers of the king than the Brehon law of Ireland. This is still restricted compared to many other codes. As more comments, Welsh law fell into the juristic category of Volksrecht, which did not lay great stress on royal power, as opposed to the Keizersrecht or Königsrecht of both England and Scotland, where it was emphasized that both civil and common law were imposed by the state.